Now I am going to dictate a legal passage based on Patna High Court judgment at the rate of 100 words per minute. Let's start. The present writ petition has been filed under Article 226 of the Constitution of India, seeking issuance of an appropriate writ order or direction for quashing the impugned order, dated 15/03/2025, passed by the District Magistrate Patna, whereby the petitioner's contractual engagement as legal assistant was terminated without affording any opportunity of hearing para. The brief facts of the case are that the petitioner was appointed on a contractual basis pursuant to advertisement number 04/2023 issued by the Department of Law, Government of Bihar. The petitioner joined the post on 01/06/2023 and discharged his duties diligently. However, on 15/03/2025, the petitioner received a termination order citing administrative exigencies and lack of budgetary provisions. Para. Learned counsel for the petitioner submits that the impugned order is arbitrary, violative of principles of natural justice and contrary to the settled law laid down by the Honorable Apex Court in the case of Menuka Gandhi versus Union of India, AIR 1978 SC 597, wherein it was held that any action affecting civil rights must be preceded by a fair hearing. Para. It is further submitted that the petitioner was neither served with a show cause notice nor given an opportunity to explain his position. The termination order is cryptic and does not disclose any misconduct or deficiency in service. The petitioner has been rendered jobless without any fault of his own, causing grave prejudice and financial hardship. Para. Per contra, learned government advocate appearing for the state submits that the petitioner's engagement was purely contractual and subject to availability of funds. The termination was necessitated due to budgetary constraints and does not warrant judicial interference. It is contended that the petitioner has no vested right to continue in service, and the writ petition is devoid of merit. Para. Having heard learned counsel for the parties and perused the materials on record, this court finds that the petitioner was appointed through a transparent selection process and had served for nearly 2 years. The termination order, however, does not indicate any prior intimation, disciplinary proceedings, or consultation with the appointing authority. Para. The Honorable Supreme Court in State of Odisha versus Binapani De, AIR 1967 SC 1269, emphasized that even administrative orders affecting rights must conform to the principles of natural justice. In the present case, the abrupt termination without notice or hearing is violative of Article 14 of the Constitution. Para. Moreover, the petitioner's engagement was governed by the term of the appointment letter, which stipulated that termination shall be preceded by a written notice, and reasons thereof the respondents have failed to adhere to their own guidelines, rendering the impugned order unsustainable. Para. This court is also mindful of the judgment rendered in Umadevi within bracket 3 versus State of Karnataka within bracket 2006 for SCC 1, which cautioned against regularization of contractual employees but did not preclude fair treatment and procedural safeguards. Para. In view of the above discussion, this court is of the considered opinion that the impugned termination order dated 15/03/2025 is liable to be quashed. Accordingly, the writ petition is allowed. The respondents are directed to reinstate the petitioner within 4 weeks from the date of receipt of this order and pay all consequential benefits para. However, it is clarified that this order shall not preclude the respondents from initiating fresh proceedings in accordance with law if any valid grounds exist for termination para. The writ petition stands allowed. The improved order dated 15/03/2025 is quashed. The petitioner shall be reinstated with all consequential benefits, no costs. Stop. Thank you.